spoke with him now.
And what did he say? Is it now that you are just telling him?
No, my lord, he's been informed.
Earlier before today?
Yes, my lord.
Okay, and you called again to
I called again that we're about to start. He said he's going to connect, my lord.
Okay. Here's the judgment of the court. A general form of complaint filed on the 6th of July 2020, the claimant prayed this court for the grant of the following reliefs against the defendants. 1, a declaration of this honorable court that the termination of claimant's employment with the first defendant company by letter dated 3rd day of January 2020 is unlawful, null and void. 2, the sum of 2,172,000 naira, being the total sum of outstanding salaries and other monies owed to the claimant by the first defendant as of January 2020, when his purported termination was communicated to him. 3, the sum of 15 million naira, being general damages for hardship suffered by the claimant throughout the period his due entitlements were withheld by the defendants and throughout the period of unlawful termination of his appointment with the first defendant. And 4, the cost of this action. It is the claimant's case that he was employed by the defendant in February 2012 by letter of appointment on a basic salary of 50,000 naira per month and equally entitled to other emolument of 10,750 naira per month after the expiration of a probation period of 6 months. He further averred that the second defendant mandated him to perform the duties of secretary when it became vacant, when that position became vacant. Claimant also averred that sometime in March 2018, the second defendant placed all the staff of the first defendant on stood off, and thereafter in April, he was recalled. Consequently, he resumed office, and upon his resumption, he collated the monthly progress reports of the first defendant to ensure the company's record was up to date. It is equally the averment of the claimant that sometimes in September 2018, when the office of the secretary became vacant, was saddled with the duties of the secretary and was assured by the second defendant that he will be paid an additional sum of 20,000 naira per month, that he repeatedly wrote the first and second defendants manually and by email demanding for his entitlement, but instead of paying same, he was issued with a letter of termination. That he subsequently wrote the defendants through his solicitors demanding for his outstanding salaries and other emoluments, which the defendants refused or neglected to act upon to the time of filing this suit. The claimant contended that the purported termination of his appointment is illegal, null and void, having not given notice to that effect, and that is entitled to continue his employment and having not breached any terms of the said employment. The defendant, by their joint statement of defense filed on 16th of August 2021, averred that the claimant was employed as a contract staff for a period of 2 years, and that the total emolument of the claimant was 10,750 naira. The defendants equally stated that the claimant and other staff of the company were paid by installment because as a contractor to government, payment from the Ministry of Works also comes by installment, and that the second defendant, being the senior engineer, merely instructed the claimant to assist in the secretarial work and offered to pay the claimant 5,000 naira out of magnanimity, acting solely at his own discretion, therefore personally liable to pay the claimant, which he did. They further aver that all contract staff, except managerial staff, were laid off in March 2017 and 2018 due to paucity of funds from the Federal Ministry of Works. Continuing, the defendants contended that at no time they jointly or severally undertook to pay the backlog of the claimant's salaries and emolument for the period of For the period, he did not work to the exclusion of other staff, that the claimant never single-handedly collated company's report, and that the claimant is not entitled to any money as salary or emolument. The defendant stated further that the claimant was never promoted while working for the first defendant, and that the sum of 20,000 naira claimed to be paid as secretary was a private arrangement between the second defendant and the claimant without the approval and consent of the first defendant. Going further, the defendants stated that they admitted by their letter in response to the claimant's letter of demand that the amount accruable to the claimant is payment from May 2019 to 2020, that the claimant is entitled to the sum of 1,061,500 naira, being his unpaid salary, and 80,000 naira being private arrangement between him and the second defendant, which sum has been paid, that the claimant, having been summarily dismissed for misconduct, is not entitled to damages. Trial commenced. Claimant testified as CW for himself. He tendered documents admitted as Exhibit A to A9. He was cross-examined by the defense and he closed his case. The defense equally opened their case, and a sole witness testified on their behalf, the second defendant. He equally adopted his sworn deposition, was cross-examined by claimant counsel, and the case for the defense was equally closed. At the close of trial, the defendant filed their joint final written address. And I've reduced that into the body of this judgment. The defendant equally filed, the claimant equally filed his final written address, pertinent part of which has been reduced into the body of this judgment. I'll go straight to the decision of the court. After a careful perusal of the originating process in the suit, the document statement of defense with the accompanying documents and exhibit tendered by both parties, I am of the view that the issues that will best determine the suit are whether this court is closed with the requisite jurisdiction to entertain this case, and two, whether the claimant has justified his claims to be entitled to the relief sought. Respecting issue one, the defendants in their final address challenged the jurisdiction of this court to entertain this suit. This, according to them, is in view of the non-service of the originating process at their head office. The question of jurisdiction is vital to the survival of an action in the court of law. A defect in competence of the court is not intrinsic, but rather extrinsic. See the case of Akande and Jegede, citation captured. Case of Beji and Uke, citation equally captured. This explains why the issue of jurisdiction is a threshold issue. Thus, once the competence of the court of law is challenged, the court is duty-bound to first assume jurisdiction to determine its competence to entertain the said suit and determine same. See the case of Silva and INEC, citation captured. Delta State versus Ulu of Warri, citation equally captured. This is because the proceeding, no matter how well conducted without jurisdiction, is a nullity. It is the defendant's contention that the claimant ought to have served the first defendant in the suit as its head office in Ibadan, and that failure to serve the processes as required by law is fundamental vice that deprives the court of its jurisdiction. The law is tried that what regulates the service of court process, the rules of court, at both federal and state levels. See the case of Mobile Producing Nigeria Unlimited versus Davison, citation captured. The case of Agib Nigeria Limited and Agib Petroleum International, citation also provided. The rules of this court specifically guides this court as regards service of processes. The rules of this court by Order 7, Rule 1, Paragraph H, provides for what will be proper service where a person to be served is a company. It provides, and I quote, if a person is a company or the other body corporate, by serving a copy of the document or process on the senior or responsible employee of a company or body corporate at its registered office or its principal place of business within the judicial division in which the dispute first arose, or if there is no employee willing to accept service, by affixing a copy of the document or process to the main door or place of business, or by posting same on the wall or the fence of the residence or place of business, unquote. The above provisions of the rules of this court is very clear and is to the effect that a company may be served through a senior or responsible employee of the company at its registered office or its principal place of business within the judicial division in which the dispute first arose, or by pasting the process to the main door or place of business. It is thus clear from the above captured provision of the rule of this court that service may be effected on the company on the first defendant at its place of business or other than its registered office. The defendants are not contending non-service of the originating process on the first defendant, but that the service ought to be made at its head office, not the branch office. I find at page 41 of the record of this court that the originating process was served on DW, one Abimbola Ogunkeyede, who is the chief resident engineer and also project manager at its office in Lokoja. Obviously, senior officer at the Lokoja office of the first defendant. This has clearly satisfied the requirement of the rules of this court as it relates to service on the company. It is not compulsory under the rules of this court for the first defendant to be served at its head office. Processes may be served on any senior or responsible officer of the company, which has been complied with in this case. It is in the light of this that I find that the mode of service adopted by the claimant is proper service. Thus, the plenary objection raised by the defendants in its final written address is countenance for lacking in merit, I so hold. To the merits of the case, it is apparent in this case that the employment relationship between the claimant and the first defendant is that of master-servant relationship. The law is of common that in such employment relationship, parties are bound by the contract of the employment, which may be reduced into the letter of employment, employee's handbook, or may be implied. Termination of employment has to be in compliance with the terms and conditions of the contract. See the case of Union Bank and Salahuddin, citation captured. Notorious case of Ibama and SPDC Nigeria Limited, citation is equally captured. A breach of the said contract will amount to a wrongful termination of the employment. See the case of Atanda H versus Safedin Transport Limited, citation provided. Claimant by his belief 1 is asking the court to declare that the termination of his employment is unlawful, null, and void. The claimant via his paragraph 30 of his witness statement on oath contended that the purported termination of his appointment is legal, having not been given any notice. Defendants, on the other hand, by paragraphs 25 and 26 of their statement of defense and paragraphs 27 and 28 of their witness statement on oath of DW statement on oath, conceded that the claimant was summarily dismissed for misconduct. It is pertinent at this stage to consider Exhibit A8, which is the purported letter of termination titled, quote and unquote, termination of appointment dated 3rd January 2020. Relevant portion is herein under captured. I quote, I'm directed by the chairman, Intercom Partnership Limited, after reviewing all your cursing, abuse, insubordination, and crass disobedience to the chief resident engineer on the engineering supervision consultancy of a project contract number 5885 section 4, Cotton Carrofield Lokoja Road, dualization to dispense with and terminate your services as resident engineer on this later project from 21st of December 2019, when the chief resident engineer directed all staff to quit the site, unquote. It is clear from the above letter that the claimant's employment was terminated and not dismissed as the first defendant alleged. It is equally evident on the letter that the termination was backdated. Effective date of the claimant's termination was stated as 21st of December 2019. Meanwhile, the date on the letter is 3rd of January 2020. Now, the question that comes to my mind is, can the above be said to be in line with the position of the law as regards termination of employment? I answer this in the negative. It is true that termination must This termination letter must therefore take effect from the date on the letter or the date the employee receives the letter, or a future date mentioned in the letter. See the case of Ude, Bunam, and FCDA citation capture, and the case of Akimbola and Ministry for FCT and another citation equally provided. The settled law that dismissal or termination of employment cannot be with a backdating effect as in the instant case. Thus, the backdating of the termination of claimant's employment is wrongful. Further to the above, I also find that although Exhibit A, which is his offer of contract of appointment dated 27 February 2012, did not expressly or specifically provide for how employment relationship of both parties can be determined. In the case of Araro Miroba Estate Limited and Orogun citation captured, the appeal court held that in a contract of employment where there is totally no written agreement as to the period of notice of termination of a contract of employment, notice given must be reasonable one. See also the case of UBN PLC and Cato citation provided. The law is settled that in a contract of employment as in the instant, the employer is obliged to give notice of termination or salary in lieu of notice. So the case of Info and Ashaka Cement Company Limited citation provided. The Apex Court in the case of Udufeco and Pfizer Products Limited citation provided went further and held that where a period of notice for termination is not stipulated in the contract of employment, it behoves the trial court to apply the test of a reasonable man to imply the period of notice that could have been adequate in the circumstances having regard to the nature of the employment. The length of service of the employee should be also considered. The first defendant ought to have given the claimant notice or pay him a month's salary in lieu of same, having served the first defendant as a pupil engineer for 8 years. This is also in tandem with Section 11, subsection 1, paragraph D of the Labor Act, cap L1, LFN 2004. There's nothing before the court to show that the claimant was given notice or paid salary in lieu of notice upon termination of his employment. It is in the light of the above that I find and hold that the termination of a claimant's employment is wrongful. Consequently, claimant's relief 1 succeed. Claimant by his relief 2 is claiming the sum of 2,172,000 as his outstanding salaries and other emoluments as at January 2020, when his termination was communicated to him. It is the contention of a claimant, read paragraphs 8, 9, 12, 18, 19, 20, 21, and 23 of his statement of facts that the defendant owed him the sum enumerated therein. The defendants in opposition stated that the claimant is only entitled to the sum of 1,061,500 naira and 80,000 naira on paid salaries of private arrangement, but the second defendant, which sum has been paid. Claims of this nature fall within the realm of special damages. The law is settled that special damages must be specifically pleaded and strictly proved. The court is not entitled to make its own estimate of such claim or engage in logical deductions. See the case of Nwangwa and FBN PLC citation captured, the case of Mobile Producing Nigeria Limited and Davidson citation captured, case of Ajibo Tosho and Reynolds Construction Company Limited citation equally captured. Relying on the above position of the law, it is my humble view that once the claimant in the suit pleaded the amount as outstanding salaries in his pleadings, that is a statement of fact, and written statement on oath, and strictly proved same by cogent and verifiable evidence, he will be entitled to the grant of same. However, the claimant in the instant case who wants the court to believe that the defendants are owing him outstanding salaries and other emoluments have failed to produce cogent and credible evidence to convince or persuade the court to agree with his assertion. Support of his assertion, claimant tendered exhibits A5, A6, and A7 and A9. A careful perusal of the exhibit tendered by the claimant show that Exhibit A5 is an appreciation letter or request letter dated 12 July 2019, and Exhibit A9, titled, quote and unquote, breakdown of Mr. Ogunjobi Abimbala Olufemi, resident engineer 1, entitlement, salaries, and emolument, is originated by the claimant, and Exhibit A6 and A7 are letters from the first defendant addressed to the Honorable Minister, Federal Ministry of Works, Power, Works, and Housing. None of these documents in specific terms constitute a proof of his claim, although the defendants admitted of owing the claimant the sum of 1,061,580 naira respectively, were claimed to have paid him. The claimant had the opportunity to either challenge or controvert this assertion by filing a reply to their defense, but failed, the import of which is a tacit admission of the defendant's assertion. Claimant did, in fact, admitted under cross-examination that he was paid a sum of 1,061,000 naira, 8 kobo, by the second defendant as his outstanding salary, but asserted that he's still being owed the sum of 990,000 naira. This is a clear indication that claimant was paid his outstanding salaries. It is therefore from all status supra that I find that the claimant failed to substantiate his claim with credible, cogent, and verifiable evidence, consequent upon which I hold that claimant's relief 2 fails. Regarding relief 3, the claimant is claiming the sum of 15 million naira as general damages. The position of the law is well settled that an award of general damages follow cause when there is a wrong. See the case of Cameroon Airlines and Ututu citation capture. The case of NCC and Motorphone Limited citation equally captured. The main object of an award of damages is to compensate the claimant for damages loss or injury he has suffered. It's equally tried that an award of general damages is purely at the discretion of the court, which heard all the parties and could easily determine what will amount to reasonable compensation to a party entitled to such an award. See the case of Aka Olisa and Aka Olisa citation provided. I've reasoned hearing before that the defendant did not comply with the terms of the contract in terminating claimant's employment in the instant case. The court has also held supra that the defendant has failed to give notice to the claimant or pay 1 month's salary in lieu of notice to him. It is in the light of this that I make an order for the payment of claimant 1 month's salary in lieu of notice in the sum of 50,000 naira by the defendant. The claimant, by his relief 4, is claiming for the cost of action. The law is settled that cost, including cost of action, is awarded at the discretion of the court, provided the discretion is exercised judicially and judiciously. See the case of Yakubu and Minister of Housing and Environment, Bauchi State citation provided. I find from the fact of this case that it is one deserving of an award of cost in view of the fact that had the defendant determined the employment of claimant as required by law, he wouldn't have been put through the unnecessary expense or stress of litigation. It is in the light of this that I exercise my discretion in favor of the claimant in awarding the sum of 100,000 naira to him as cost. The judgment sum is to be paid within 30 days from today, failing which it is to attract 21% simple interest per annum. Judgment is accordingly entered.
And God pleases. Hello, sir. We are going to appreciate a lot the time, the indulgence, sir. And I wish you a lot a very happy New Year, sir.
Thank you very much. I wish you the same.
Thank you, my lord.
All right, a copy of the judgment will be sent to Lokoja for parties.
As God pleases, sir.
I'll rise.
We are grateful, sir.